Great. So anytime you want to chime in or say anything or make a comment, please let me know. Today I kind of wanted to talk to you a little bit about this idea. It kind of comes out of me reading a lot of law review articles on how we need to punish prosecutors, as far as prosecutorial misconduct. I think we all have read stories in which we kind of scratch our heads like, why would a prosecutor not disclose exculpatory evidence that could help a defendant in a case? And why is that so difficult to be able to do that as a prosecutor? And so I started thinking like, wow, well, how can we support prosecutors in becoming what I'm calling now balanced? And I'll kind of explain that as I go through this. And this really started, I went on a field trip with some of my students who are interested in practicing criminal law. There's something called what we call the Day Reporting Center. And it serves kind of as an alternative to incarceration by placing eligible participants in structured and intensive outpatient programs. So it's kind of a program where they go and they learn about rehabilitation for substance abuse, and it's a way for them to kind of bridge the gap between prison and going out and finding a job and trying to work on rehabilitation. And so they go to this Day Reporting Center to go through some treatment programs during the day. So I took some of my students there, and we had about 5 people that were going through the program that were there, and they were willing to share their personal stories with us. And I'm sure, some of you professors, maybe not, maybe it's just me, but I sometimes have the tendency of students that are in class that are kind of doing this, or talking to their colleagues. This was not the case when I went to the center and they started sharing their stories. You could literally hear a pin drop. And the students were riveted by their stories, and to hear the process of becoming addicted to drugs and how that led them to commit larceny crimes, and how they got involved into the criminal prison system, and then what changed their mind and made them want to work on their substance abuse issues. And in a break, I went with one of my students. We were walking to the bathroom, and she has always wanted to be a prosecutor. And she said to me, she said, wow, she's like, I externed at the prosecutor's office this summer, and I've just always thought that if you commit a crime, you should be locked up and throw away the key. And I've never really thought about, their own personal stories and what they've gone through in life to get them to the point where they're beginning to commit crimes. And all I remember is thinking like, holy cow, this was the exact reason why we need to be going out. We need to be hearing these stories, and we need to be educating our students to learn about the other side, right? And looking at it from different perspectives. So it really got me thinking of the To Kill a Mockingbird quote. Of course, I just love To Kill a Mockingbird. But Atticus Finch said, you never really understand a person until you consider things from his point of view, unless you climb into his skin and walk around it. And I started to think about how difficult I'm sure it is for prosecutors who really never really get in touch with the defendant. In fact, it's the system is designed so that you don't talk to the defendant, but you have to hear it through a defense counsel. How difficult it would be for them to feel that type of empathy. And not only that, I started evaluating how we teach our students in law school. And essentially what we do from day one in law school is we tell them, forget about that emotions. Forget about the facts that don't apply to the rules that you then have to analyze and come up with a rational, logical answer, conclusion once you've analyzed the rule of law. And I started to see that for students, it's very uncomfortable for them to even address the issues that they're feeling within the case, within perhaps a client, because in law school itself, we really don't discuss the emotions behind it. And then you add on top of the fact of stress that they feel in law school, right? We all have pre-law stress, right? Just dealing with being in the world today. But then you add trying to understand how to identify issues, apply the rules, and then analyze them, and the stress and the competitive nature of law school, and the fact that the mentality kind of is like, hey, we learned how to swim, you should too, that you start to see that they are seeing this stress. But what we identify in law school is basically just to teach them how to think like a lawyer, which, don't get me wrong, is an incredibly important, obviously, skill that we need to teach our law students, how to think like a lawyer. But we don't seem to really talk about the practice of law as much, and the stresses and the adversarial environment that they're going to be dealing with when they're in law school, right? And I think that what we've done as far as culturally around the practice of law is to perpetuate this. Look, you got to work hard in law school. You got to manage your stress so you can get good grades and be able to understand the lawyering skills, so that you can then go out into practice, work really hard, and then manage the stress of somebody else's problems. But we don't really talk about how to do that. Which gets me to thinking of it more from the prosecutorial role and the environment that we put the prosecutor under. Because again, I'm trying to understand why really good people could turn around then in practice and demonstrate that that they're going to win at all costs. And I think we have to address the fact that law simply puts us in this adversarial process where we essentially are in conflict, because we're dealing with our client's conflict in relationship to opposing counsel. So if you look at the prosecutor's role, they're really juggling with a lot of things, right? First of all, they're essentially a law enforcement officer because they're working with police officers, law enforcement agents, and they're trying to gather facts to see if there's a sufficient case. Is there probable cause beyond a reasonable doubt that we can meet the elements of the crime? But not only that, they have to, in a sense, also have the role of the judge, because they have to evaluate the evidence to see if there is potentially some sort of suppression issue, some sort of violation, constitutional violation. And then they have to turn around and they have to be advocates for their own particular argument, whether that's the same as the law enforcement officer or not. And I found it really interesting. This study was done in the 90s, but it was kind of a contrast between a survey done of Japanese prosecutors versus prosecutors from Seattle, Washington. And they found that the number one priority of prosecutors in Japan was discovering the truth, which makes sense in a sense that that's apparently what justice is supposed to be about, right? We have a trial and we have two opposing sides, right? We have the government saying, this is what we believe you have done, and this is in fact is a crime. And then we have opposing counsel, defense, saying, no, you've got it wrong. We actually have a defense, or you haven't proven all the elements. And then they're fighting. And then magically the truth is supposed to appear. We discover the truth through this adversarial process. And then magically we have truth, and then therefore justice. But then when they surveyed the prosecutors from Seattle, they found that their number one priority was protecting the public. Obviously, I mean, truth was number two. I'm not saying that they don't feel like they're discovering the truth, but it's this feeling that I have to make sure that we put people away that have committed crimes, because my purpose is to protect the public from people that are committing crimes. This relates a lot to things that you typically see prosecutors say, right? Prosecutors are described as self-righteous, consumed with power, swayed by their own propaganda, and God's designed hitters in the World Series of life. These are comments that are made about prosecutors. Here's a comment from an actual prosecutor. It really came down to ultimately to getting a plea or winning a trial, so I could go home that day and say, okay, I won today. That game is over. And again, that makes sense, because in an adversarial system, there's winners and there's losers. Somebody's going to win. Here's one: prosecutors don't see themselves as the conscience of the community. They see themselves as having a job to do, needing to win that job and to go on to bigger and better things. Again, that win mentality. What the new prosecutor is taught is that no matter how solid a case he has, there's always a possibility that he'll lose at trial, and a defeat at trial means total loss. Do you see how this does not complement the idea of discovering truth and searching for justice? The prosecutor's job is constantly pushing the edge of the envelope out to see if you can get an edge for the prosecution, because you're trying to get every edge you can on those people who are devising increasingly more intricate schemes to rip off the public, hiring the best lawyers and providing the best defenses. Again, meshes with this mentality of the us versus them, prosecution versus defense. Here's Ken White, a former federal prosecutor, who says, there are three types of culture: the culture of the prosecutor's office, American popular culture, and the culture created by the modern legal norms of criminal justice, shaped how I saw the rights of the people I prosecuted. If you'd asked me, I would have said that it was my job to protect constitutional rights and strike only what the Supreme Court once called hard blows, not foul ones. But in my heart and in my approach to law, I saw rights as a challenge, as something to be overcome to win a conviction. Nobody taught me that explicitly. Nobody had to. Again, referring to the culture within a prosecutor's office. American culture relentlessly tells prosecutors that they are, by definition, the good guys. It tells them that assertions of rights are, at best, impediments to be overcome, and at worst, cynical ploys by villains. It's tremendously difficult to ignore those cultural messages and give defendants constitutional rights the attention they deserve. Again, he's describing that it's very difficult for him to have the judge hat on if he also has to have the advocate and law enforcement officer hat on as well. This makes for a strong team, but it doesn't encourage introspection about wrongdoing. And so I kind of show you here, one of the most famous American prosecutors is Vincent Bugliosi, who prosecuted the Charles Manson murders. And then, of course, we have Marcia Clark here. But the description of the typical prosecutor that we've seen is much more on the side of assertive, aggressive, ambitious, competitive, dominant, independent, forceful, and obviously, very logical, right? We don't see much on the side of empathy, compassion, kindness, equanimity, things like that. However, we're starting to see a little bit of a shift that I kind of want to talk to you about. Again, traditionally, we focus from the very beginning in law school on logic and reason. Emotion is somewhat frowned upon as far as at least law school is considered. That doesn't seem to go towards the logic and reason to develop the correctly analyze the law. So I wanted to ask, and I was kind of curious, is it possible to allow for emotion and reason? And is that in fact better? And so I started reading a lot about empathy and the importance of empathy, and how important it is for clients to feel that their lawyers are empathetic, and how difficult it is for prosecutors to demonstrate that without having a naturally empathetic personality, or not having that opportunity to be empathetic. There was an interesting study that came out of Sweden in which they conducted an experiment to see how empathy might increase a prosecutor's effectiveness during the investigative, trial preparation, and trial phases. They found that at the investigative phase, as they were interviewing a wide variety of prosecutors, they said that displaying empathy towards law enforcement or an eyewitness could help the prosecutor better understand the crime scene, how the events unfolded leading up to the crime, and what type of crime should be charged, who should be charged, and the motives behind the unlawful behavior. At the trial preparation stage, displaying empathy towards witnesses, victims, and police would improve the communication and allow for more candor as the prosecutor asks for more difficult information, including facts that might be embarrassing to share. And empathy would reduce a witness's anxiety over having to testify and wondering what types of questions might be asked. And lastly, at the trial phase, they said empathy in the courtroom would help ease the fears of the witnesses, calm the victims, and it would allow for individuals to feel seen and heard. And lastly, demonstrating empathy towards the defense would help the prosecutor understand what it is the defense counsel and their client want, and empathy can disarm one's adversary and help dampen any ill will. This is really, at least in legal scholarship here in the US, we're not talking about. Nobody's talking about empathic prosecution, let me just tell you. It's all about vindictive prosecution and how do we punish, and how we should limit perhaps immunity for prosecutors so we can punish. And again, I'm not necessarily saying we get away with those, but I think there's a way we should start thinking about how we can support empathetic prosecutions. And that led me to what our American Bar Association standards are for prosecutors. And things just started popping out of the page to me that address this idea of empathy, right? That the prosecutor's office should exercise sound discretion. How do you have sound discretion without being able to be empathetic? Balanced judgment, exercising discretion, respecting the constitutional and legal rights of all persons, including suspects and defendants, considering alternatives to prosecution, assisting community efforts. Being a problem solver would mean that you would have to look at it from other perspectives to be able to make that decision. So this leads me to my buddy, the Dalai Lama. At the time I started doing this research, I was reading this book called The Book of Joy. And it's a book written by the Dalai Lama and Archbishop Tutu. And they were asked essentially in the entire book to explain, how the heck are you guys so joyful? What is it? What's the magic sauce that makes you so happy? And this is the secret that the Dalai Lama shared. He said, we're most joyful when we focus on others and not ourselves. You see, in order to become a happy person, we need to live more from the compassionate part of nature, and to have a sense of responsibility towards others and the world we live in. In this century, if we make an attempt with realistic effort and clear vision, perhaps in the later part of the century, we can really have a happier world, a more peaceful world, a kinder and more compassionate world. And so I started thinking, wow, if you could make it so that you're not trying to impose, you need to be empathetic because it helps the other guy, but in fact, reversing it to say, the people that are most joyful in life are those that actually make an effort to focus on others. And in focusing on others and finding a way to be compassionate towards others, in return, you will feel happy and you will be joyful. Then we've got a hook with prosecutors who are going to say, well, yeah, who doesn't want to be happy? Who doesn't want to be joyful? And so I think we need to start thinking about ways, even in law school, to start incorporating this. And before anybody starts thinking, oh boy, here goes Reid again. She's just being like, Pollyanna, not thinking she's going to like say, oh, all you criminal defendants, open the prison doors, let them out. That's really not what the Dalai Lama is saying. In fact, he's saying in order to be compassionate, you do need to hold people's feet to the fire sometimes. So he says, you must not hate those who do harmful things. The compassionate thing is to do what you can to stop them, for they're harming themselves as well as those who suffer from their actions. Forgiveness does not mean you accept or approve of wrongdoing. When the wrong action is concerned, it may be necessary to take appropriate counteraction to stop it. Towards the actor or the person, however, you can choose not to develop anger and hatred. This is where the power of forgiveness lies, not losing sight of the humanity of the person while responding to the wrong with clarity and firmness. We stand firm against the wrong, not only to protect those who are being harmed, but also to protect the person who is harming others, because eventually they too will suffer. So it's out of a sense of concern for their own long-term well-being that we stop their wrongdoing. So what we're saying is not necessarily we need the compassionate act of not prosecuting, but we have to be able to take out our own personal feelings of hurt or vengeance, and develop that anger or hatred. No, what he's saying is we need to have the power to forgive, but also stop them from hurting others and hurting themselves. And I won't get into like the specifics of the book, though I highly recommend it. But he talks about the pillars of joy and what leads to this: perspective, humility, humor, acceptance, forgiveness, gratitude, compassion, generosity. And obviously, I mean, I think the Dalai Lama says in his book, he gets up at like, I don't know, something like 3 a.m. and he has his routine to get him into this joyful state and more compassionate state through meditation. Obviously, we can't be waking up at 3 a.m, but I think that we can, if we have this type of mindset, I think we can develop processes during the day to kind of remind us of this, because we see what an impact it would have, particularly in the area of prosecutions, as I'm talking about. So what I'm thinking is, I think it's possible that we can teach students thinking like a lawyer, and also saying we can't repress and suppress emotions and put that aside, but also address that and develop a sense of empathic concern for others. Because what that apparently, according to the Dalai Lama, says is that then creates a game plan as far as how we want to act, and not necessarily react from the charged reaction of the situation, but also decide how we want to act, and also what kind of compassionate acts we want to do. Empathy is kind of feeling what someone else is feeling, and then in reaction to that, the compassionate words that you provide them with. And that, in a sense, leads to joy. What I'm seeing now is, in the last, I don't know, I think it started in 2014, I'm starting to see a little bit of a shift in various prosecutors' offices. And we're starting to see some of this empathy as these progressive prosecutors have been elected. So here's one, Rachel Rollins from Massachusetts. Today's defendant is potentially tomorrow's victim and was yesterday's witness. And so if I treat you horribly as a defendant, but then want to be nice to you when you're a victim and ask you to come forward when you're a witness, people aren't stupid, right? So she's thinking about the role of the defendant, how they were yesterday's witness, identifying their past, and how should we look at them? There are a lot of men that are very, very nervous about it because we're looking at things differently. And the system is now going to work the same for everyone, and not just those that understand it or have access. I come to work with a very different lens every day. Here's James Comey. Hopefully you guys remember him. I thought I was very intrigued by he had a lot of empathy, and I attribute a lot of this to the fact that he was a victim when he was a teenager. They had a home intruder that came into his house, and he and his brother were by themselves, and were beaten up, and the guys stole from them. And he was he's kept that those thoughts of being a victim all these years, and you can see his empathy on display. We don't want to swing at the wrongdoer and knock down 50,000 innocent people. But by the same token, we can't allow the corporate wrongdoer to essentially take his or her employees hostage every time we come close and say, you can't prosecute this corporation because you'll hurt all these innocent people. There are corporations that have a profoundly screwed up culture. At some point, we have to say, look, we need to put you out of business. We need to hit you. We need to kill you because you're bad in your own right and also serves the broader purpose of deterrence. But what he's saying here is he's reflecting before he just haphazardly has, some prosecutors indict an entire company. He's identifying the fact he understands the implication of an indictment in a white collar case when you're indicting a company and what the impact that might have. Another DA in Orlando, when a diverse prosecutor sits in this chair, we should be expecting diverse thought as a result of diverse experience. Here's Alvin Bragg, New York County District Attorney. This one's interesting. He said, as a candidate, he spoke about gun possession cases, and he said he wasn't going to prosecute those. However, while in office, there was a string of shootings, and he said that he'd been overly focused during the campaign on what he called exceptional cases in which gun possession should not be prosecuted. But since taking office, I realized I need to be more clear about when traditional prosecution was called for. It's certainly a change in emphasis. It's certainly not a change in my thinking or in my work. What this shows is the ability to reflect, that I made these statements before I took office. Something's changing my mind in office. I realize I need to be more clear, and maybe the traditional prosecution was worked. And so this is why I'm going this way, explaining this and showing his reflection. He said, there are a lot of stakeholders, and I'm going to continue to listen and talk and hear what people are saying. But ultimately, I have to do what I did before I was in this office, look at the cases and do what I feel is right. Here is the King County Deputy Prosecutor that's in St. Louis, Stephen Thomas. And he said that as a prosecutor, you see that kid as a victim, but then 10 years later, when he's dealing with the trauma of the event without any support, without any services, without any connection, we're trying to prosecute him and send him to prison for as long as possible. And that type of culture and that type of mentality has to be uprooted. Again, he's identifying that the defendant is an individual that has past trauma that has led him to where he is today. I'm the one who believes in redemption, one who believes you're more than the worst thing that you've ever done, and that you're more than the worst thing that has ever been done to you. And I know that not because I read it in a book, but because that's my life. Because I believe Stephen Thomas had been in a gang when he was a young teenager, and then he turned his life around. So he had that experience and knows, understands these defendants. He claims to lead with a heart of compassion as the prosecutor, not just for Seattle, but all of King County. Okay, Wesley Bell's the one from St. Louis. That's right. Wesley Bell, they ask him, what parts of the job do you micromanage? He said, issues that deal with victims and their families. I make it a point to meet with as many people as I possibly can. I want them to be able to look in my eyes and ask questions directly of me. I also try to go whenever I can to homicide scenes, talk with the family, and hug them. I wasn't sure how I was going to react. I'd served as a judge, and judges don't go to homicide scenes, and neither do defense attorneys. A few days after I was elected, there was a homicide, and I went to the scene. The hardest part was talking with the family. The victim was an older woman, but she'd been very active, and she had a family who loved her, and they invited me to her wake. Again, people want to be seen and heard, and these prosecutors are making an effort to demonstrate their empathy and their concern. Oh, this one's my favorite. This was Keith Ellison. He was the lead prosecutor in the Derek Chauvin case. I don't know if you guys remember the Derek Chauvin case. He was the one he was the police officer who had placed his I think it was his leg on the victim's throat. And he was the lead prosecutor in the Derek Chauvin trial when they were prosecuting him for murder. And they said, when you first heard the word guilty, what did you feel? And he said, gratitude, humility, followed by a certain sense of, I'd say, satisfaction. It's what we were aiming for the whole time. I'd spent 16 years as a criminal defense lawyer. So I will admit, I felt a little bad for the defendant. I think he deserves to be convicted, but he's a human being. The interviewer asked him as the lead prosecutor, I didn't expect to hear from you a note of compassion for the defendant, Derek Chauvin. He said, I'm not in any way wavering from my responsibility, but I hope we never forget that people who are defendants in our criminal justice system, that they're human beings, they're people. I mean, George Floyd was a human being. He had been the victim. He was the one that had been murdered. And so I'm not going to ever forget that everybody in this process is a person. So what we see here is we start seeing this trend, right, of these progressive prosecutors that are coming into office. Now, they are elected based on, obviously, policies, particularly to end mass incarceration and bring fairness to the criminal legal system. A lot of them are focusing on the bail reform, the marijuana cases, expanding diversion, so alternatives to sentencing, things like that. The problem being is that we now start to see a divide between progressive prosecutors and the traditional tough on crime prosecutors. And so we're starting to see pushback from the traditional cultural model of prosecution, right? The traditional model, they're saying the new progressive prosecutors are promoting lawlessness, anti-law enforcement, they're dangerous to the public safety, there's more crime, there's more victims. What they're after is to destroy the system. That they very deeply misunderstand. This isn't progressive, it's not reform. So the problem is this display of empathy has now become politicized. And that's what I worry about, right? Because now we're seeing tough on crime prosecutors are going to be like, oh, this is just policy driven, rather than this joyful model shift that I'd like for us to see. Here's Steve Cooley, again, showing the traditional model. I want George Gascon to be replaced as district attorney because he functionally with his policies are endangering the public. He does that through his many directives that basically show great sympathy and empathy for criminals, especially violent and serious criminals and murderers. And the problem is that the public perpetuates this, right? Because prosecutors try to get elected and say, I'm tough on crime. I've prosecuted all these, DUIs. I've prosecuted all these murderers. You should vote for me because, people want to feel safe. So we start to create these political battle lines. What I'm trying to say is empathy and the joyful model shouldn't be politicized, right? That we could actually, if we really wanted to, empathy, even if you don't intrinsically have empathy, I've read enough books now to say it's a skill that can be learned and developed if we value it. And if we want to push this, we should be pushing this both at the law school level as well as try to help our prosecutors in developing the skill, right? So my suggestions would be, we need to, instead of just focusing on the district attorney that's being elected, we've got to focus on the line prosecutors, right? Because if we have a progressive prosecutor and then all these prosecutors that think that this is just policy driven, they're going to stick with the traditional model and think empathy, that's for those progressive types. That's not me. But I think if you focus on the line prosecutors, I think then you're much more willing to see a change in the culture. Now, what do I worry about? Oh, Reid, this is too simplistic. You're an idealist. This is nice and all, but can it really happen? I think the buy-in is critical, again, which is why I think that attacking prosecutors and that immediately puts them on the defensive, whereas you can't really argue with joy. I mean, who's going to sit there and say, I don't want to be joyful? Or even I don't want to be, I don't know, maybe people do. Maybe people like to not be joyful, maybe. But I mean, I think you have to really be intentional on how you're going to get this buy-in and what this joy and empathy is going to look like. Like I said, I think we need to bridge the divide. I think we need to stop the distinction between the two. And I think, you have to go back to the basics. Here's Justice Robert Jackson's idea of, therein is the most dangerous power of the prosecutor, that he will pick people he thinks he should get rather than the cases that need to be prosecuted. And only a human being that is emotionally regulated, that can look at it from a wider perspective and see the different perspectives at play, can really make that determination and see the distinction between the two of who you should get versus who needs to be prosecuted. And then I think going back to my title, right? What a balanced prosecutor, what I think that is, the ability to be able to think like a lawyer, but also to be able to display those signs of empathy. So I think that we need to give a life raft or, inner tube at least, first of all, to our law students. I think from day one, we need to inform them that we care about their well-being and we wanted to help them develop the skills necessary, definitely to think like a lawyer, but to become a well-balanced lawyer. And then I think we need to see the change in the actual culture, right? If you're joining the DA's office, it had effective leadership. It has to come from the top, that we care about you. We care about victims. We care about the defendants whose lives we touch every day. And we trust you'll make a fair assessment and act with integrity and balanced judgment in each and every case. And I'll close with my Dalai Lama because, such a good book. No dark fate determines the future. We do. Each day and each moment, we're able to create and recreate our lives and the very quality of human life on our planet. This is the power we wield. Lasting happiness cannot be found in pursuit of any goal or achievement. It does not reside in fortune or fame. It resides only in the human mind and heart. and it's here that we hope you'll find it. Boom, drop the mic.
Thank you for giving us so much joy.
My pleasure.
It was extremely thrilling and such a lot of things to think about. I mean, I only understand now. I only understand now how different our systems are, and how different our approaches are. And I'm wondering, since you're sort of focusing on the mindset of the prosecutor, which is absolutely an important issue, but which would not be the first European reaction to this question. The first European reaction would be how to amend the law, how to change the law. But that's absolutely thrilling. But I think it's absolutely necessary to take this approach under the American system, where you've got this adversarial trial and you elect your prosecutors.
Yeah.
So that's absolutely different. But I don't want to bother you with what I was thinking when I was listening to your presentation.
No, please, because that's
Really
actually
thrilling.
my next paper. Is I'd love to do a comparative piece to try to be like, we need to think of the European model more.
Yes.
Because I think you do have more balance than we do. I'm just being honest. I really do.
I was wondering, perhaps might I ask just one question out of many that I've got and that we have to discuss at some point?
Yeah.
Do you think the adversarial model, with this tough on crime focus, is a successful one? I mean, do you get more criminals? And I don't mean the sort of petty criminals, but the really high stake cases. Do you get more people prosecuted and sentenced than under a different? Are there any empirical suggestions that this tough on crime adversarial model is particularly successful? That's what I'm wondering, because
I mean, I can tell you that we incarcerate on a much higher level than any of your countries. That's for sure. I mean, who we're incarcerating? Are we incarcerating the most dangerous that need to be? I think we're doing that and more.
Mm-hmm.
I think our gut reaction is, we don't know what to do with them. Let's incarcerate them. Let's prosecute more. I think that's our go-to. So are we getting more criminal defendants? Yes, clearly from our incarceration rates.
Okay.
Is that effective? I mean, I don't know about that.
But do you get the really dangerous ones? Is it easier to get them under this model? I mean, are they successful in trying to find every possible way to, even if it's a little bit, if it's a way that might be regarded as some sort of circumvention of, you quoted this question of constitutional rights, and that they were trying to sort of get around it if they want to get someone really bad.
Mm-hmm.
Working?
I think because while we say in abstract that this model of prosecution versus defense is a balance, I think that that's not necessarily true, because I think the government has a lot more resources than the defense does, unless you have money.
Mm-hmm.
So I would say if you have a lot of money and you're a criminal defendant, you can buy your way into getting a good lawyer and getting off. But I think the majority of the criminal defendants can't afford that, and they have a public defender who has hundreds and hundreds of cases, and you're not going to get the the advocacy and the necessary defense that you need to fight the government resources. So yeah, that's a problem. Yeah.
Right.
So what do you think in comparison then? Do you think that your prosecutors don't have this problem?
If you allow me, first of all, let me make a joke. I don't believe that anyone that wakes up at 3 in the morning can be joyful, not even the Dalai Lama. But after saying that, I agree.
He does say he goes to bed at 7 p.m. He does say that.
Another problem. Something that goes to bed at 7 in the afternoon cannot be joyful. But well, that's just a difference of perspective. But regarding your very interesting lecture, and I liked very much, I believe indeed there is here a difference of conceptions about the penal process, and not just the penal process, all the process in general. Because as we have the contradictory, the idea that there are parts they should discuss with them, and the object of the process is made of that. But not in penal processes. Because in penal process, if the prosecutor thinks that the criminal, the guy that is alleged to be a criminal is not guilty, he should plead for not guilty and not for guilty. So the contradictory in our system, and Germany and Portugal and other European systems, stops in the penal process, is the only process that is not just completely contradictory. It has some of inquisitory power on the judge and on all of the members. But having said that, I agree completely with your idea of empathy. Empathy with the guys that are alleged to be criminal or they are in the process. And I believe that empathy is not just with the prosecutors, with the guys that are being in court, but also between everybody that is in a court. And we need to have, and the empathy is a quality that is needed for a judge, is needed for a prosecutor, and needed for a lawyer. And the only thing I did not agree with you, and you say you should think like a lawyer, because a lawyer can have also no empathy of any kind to the person he represents or the person he's playing with. And the lawyers also have some prejudices, some ways of doing. The fight for money sometimes disturbs what they should represent, and they need more reason, more empathy, and this kind of thing. But I can talk about an experience that we have in Portugal in the school for judges. There is at the same time the school for prosecutors. They are formed together. And in the last years, there are some courses designed to create empathy with the people that are being judged. They have special plays, they do plays in order to show this kind of thing. They attend to the movies, they have to discuss movies. The one that you brought us was wonderful with Gregory Peck in a special position. I like very much. And that's something they try to create with cinema, with theater plays and this kind of things. And they try to make persons more engaged in good feelings, in empathy, in pursuit of justice, but also in reason, because both things are necessary. And that you said that reason should go with empathy, I'm 100% for, and I like it very much. So in general, I agree with almost everything. But also that's very interesting. I think it's something that you should do. Try to do a comparison. And when you are in Portugal, I'll try that you can meet a penal law professor, a penal process law professor, and perhaps why not, if you can come to the School of Judges and have contact with them, because this idea of comparing, it's a great idea. But I liked very much your lecture. Congratulations! It was really not just in the concept, but also in the form. Great. Congratulations.
Thank you. It sounds like we've got a future article we got to write. Portugal, Germany, and US.
Yeah, cool. We should.
That's great. I do want to, if you have just a second, I don't know if everybody's got to go, but I will say I've been thinking a lot after doing this research on how we can address this at the law school level, because I've had too many alumni that come back, and either as prosecutors, they become kind of robotic, like, you become so used to the caseload and doing the same thing, you kind of lose that perspective of individual cases, as well as alumni that are not practicing even in the criminal law, but in civil law, that they're just experiencing real burnout from the work culture, as well as from this lack of dealing with the emotions that are surrounding the practice of law, right? Because lawyers, we sometimes tend to suppress it or resist it, or we come at it with like a charged reactivity because of being in that conflict. So I was thinking about it, and I decided I was going to try an experiment, and I hired a trainer who has been a therapist and social worker for about 40 years. And she also has consulted with CEOs, and she has her own clients, and she works on specific processes that she can go through with a client who has like a particular, conflict or problem with a goal in mind. And she can, in about like 20-30 minutes, they can go through the process. And what they basically do is they kind of identify the emotion, the body sensation that you feel when you feel that stress emotion or whatever, anger or whatever you're dealing with, and whether you have an image or not, and then the thought associated with it. You process it and integrate it, and then on the other side of it, you feel some sort of space within that, then you're not so charged. So then you can look at the problem without bringing that excess emotion to it, to be able to think through it, because you process through the emotions associated with it. So I was like, oh my gosh, this is amazing. Like, I love this woman. So I brought her to the law school, and I had, our students, our second year students are just about to do oral arguments. It's like their moot court. As a second year, you have to write an appellate brief, and then you have to you do this oral argument. So I said, perfect. I'll bring her to the class. And it was like 3 sessions. So we put them all together, about 60 students in our courtroom, to do a 2-hour session to learn this process. So that might be able to calm them and calm their nerves before they do their oral arguments. Okay, so I bring her in, and I know how important it is to do the buy-in, like how important it is to explain how, it's important as a lawyer to be able to process your emotions and understand that this is stressful. So she starts talking about it, and then she goes right into the process with them, which essentially, you have to actually think. First, you have to kind of close your eyes and think about the stressful moment, then think about like a non-stressful moment. So like, if I'm stressed about giving a presentation today, I would really feel it, right? I would think about it, identify how my body's feeling, And then I would go to a moment of not stress. So I probably would think of myself on the beach, reading a book, feeling the sand, watching the waves, and all of a sudden I feel a lot better. And then you kind of keep going back and forth from the stress to the not feeling the stress and your happy moment. And it gets to a point where you feel they almost start to merge, and they kind of almost seem to disappear, because you're going kind of back and forth, and you start to feel like a space within it. And I mean, I guess we could try to do an example, but what I'm saying is like, we went through this process with the students to teach them this kind of technique. I was super excited. You know what happened? I've never gotten worse survey results back in my life. I mean, the students were like, are you kidding me right now? Are you really wanting me to feel my emotions? I've been here for 2 years, and now you like all of a sudden, I mean, I was like, oh my God, this is a disaster.
Well,
Well, the moral of the story is, I think that this is not something that you can just sprinkle in here and there. You can't give a 2-hour empathy session or here's how to not be stressed technique in like 2 hours and expect that to make a difference. You just can't. And so like, we have to commit, as a law school faculty or whatever, is this something that's really important? Is mental health and emotional regulation important that we try to assist our students? Or, I mean, for us, the average age is 25. Maybe you almost have to go through some real hard knocks, some real life experiences before you realize that maybe it is important to like do these types of techniques to help you. I don't know. I mean, I'm just telling you this personally because I'm working really hard at this to try to figure out whether this is something that in the future with legal education we need to like consider, or do we keep doing what we have been doing in law, which is like, hey, I'll teach you how to analyze and read law, and you guys figure out the stress part of it. I don't know. There's no right or wrong answer. I'm just kind of anecdotally telling you kind of what I've been kind of working on and trying to figure out. But I did learn that you can't do it in 2 hours.
If I may ask there, inspired a little bit by your last remarks, and of course in the aftermath of the popular elections some days before. Do you think that the popular vote would aim at people being empathetic, or do you think that that's quite a difficult question, I guess? Do you think that voters would go for the law and order guy, or for a more empathetic guy, or in other terms, is the matter of empathy for empathy maybe a local matter, which would be answered differently in different parts of your country?
What do you mean, like a local matter? Like
so I guess that, of course, we hear that the election results differ from part to part in the US, and there are more conservative approaches and more liberal ones, of course. Do you think that the matter of empathy for empathy in order to elect the empathetic guy, or the more I don't know, law and order guy, the hardliner, if you will, would you consider it a local matter maybe, or is it indeed something which would have to be developed through the law schools before?
I think it's totally become politicized. I think that the tough on crime is associated with conservative politics, and the progressive prosecutor is much more liberal Democrat. And that's where you're seeing voting as far as prosecutors. You're seeing that happening in, San Francisco, places in California. Here in Tennessee, there's no way we would have a progressive prosecutor. And people just don't identify it as, oh, they're empathetic and they're not. It's just politics. It's lined strictly political. So I don't know.
So a campaign of a person based on, you know, I'm a neat guy and I could be empathetic if necessary. Could such a campaign be successful at the end of the day?
I think it depends where you are.
There you go. So it is at the
It
end of the
is.
day a local matter, obviously.
It is a local matter. You're right.
Thank you.
You're right. I don't know. I will say before I stop talking about this, I know I'm talking too much about this, but I will say medical schools have addressed this, and they talk about empathy and patient narrative and making the patient feel seen and heard. Why we're not talking about it in the legal context that much, I'm not sure.
Yeah, you are absolutely right. I think it's important. And I believe the experience they had at the judge school was really that, doing that with the art and using the art in order to create this kind of empathy. I think that's really important.
That's great. I can't wait to learn more about that, Lashko. That
Well,
sounds really.
I'm thinking that the president of our scientific council, that is a colleague, has been for some years president of the School of Judges. So perhaps it's easy to find him. Is at the faculty. I'll bring it to him when you come to Lisbon, because he can talk about that experience that he tried there at the School of Judges. But I believe you are perfectly right. We need to create a different environment in law and in the application of law, and that goes from the prosecutor to the lawyer and to the judge, and we need to look at with a different approach that includes emotion. We talk nowadays about the emotional reasoning. That's a part of it. The reasoning is also something that has to do with emotion. So
Yes.
we need to control that part. There was a time, well, sharing experience, there was a time I was in Brazil, and I discovered there is a great movement between judges in order to spread the idea of emotional reasoning. And I even attended one or two actions that were integrated in my congress, and I had time to do it, and so I did. And I found different and interesting. It was a good experience, let me say, to attend it. So probably you are right about your exercises, and you could try more.
Yeah. Again. Yeah. And looking back now, I think it's unfair to ask people that are used to an environment in which we don't discuss emotions or how my body's reacting to like to go in there and then like say, okay, now feel your emotions. I mean, they all kind of like looked at me like, what are you asking me to do? Like, this is not a typical law exercise. And you want me to feel my emotion? You know, yeah, it was a good experiment for me, because I learned a lot from that, to say like, yeah, you can't just throw people in the water and then expect them to, you know, be able to address that when you got to get them to slowly swim before you can address that. Or maybe it's not something that should be even part of legal education. I don't know. It's a fun thing to think about, though. I mean, especially when the surveys, at least from the US law schools, are that, I think, forget what they said, it was almost like 60% of our law students here have some sort of mental health issue, whether that's anxiety, depression. The last survey said that 11% have suicidal thoughts. I mean, that's a lot. They surveyed all these law schools in the U. I was like, that's what shook me up, because I was like, wow, we need to address this. We need to figure out what's going on. And I know some of it's probably post-COVID and, you know, the shift, but I mean, we're crazy not to talk about this and figure out how we can support our students and figure out what they need, you know, to help them. Because legal education isn't supposed to be a drudgery that's like, You know, like we want to get them excited about being here and about practicing law. So what can we do? I don't know. Any of your students out here, do you guys have any ideas? Anybody that's here?
Hello? Do you have any ideas?
Anybody? Any student here?
Luisa, Luís Cruz, Beatriz Veríssimo.
Perhaps
What
I
is
might
what?
ask, I might ask another question. I don't actually know what we are doing here as far as such courses are concerned. I'm quite sure that I myself would have been a little bit astonished, but well, when one is young, one is astonished at a lot of things. I do know that we've got courses on legal psychology in Hanover. I don't know what they're doing, but I know that that's a psychologist that's doing these courses. They are doing it in the field of criminal law, so you would have to discuss that when we talk about that in Hanover at some point. Possibly we can find out about that. But I was wondering concerning empathy and including this topic into the everyday life of a public prosecutor. I absolutely agree that it's necessary to change the environment and to change the basic settings and to alter the approach. But wouldn't it be necessary too, and sort of a prerequisite to this, to get clear about the task of the public prosecutor? If the task of the public prosecutor is to find a way to which is beneficial for society and society, both for the victims and for the perpetrators, then it's completely different matter, in my opinion, as if we see the task of the public prosecutor in just locking people up. So wouldn't it be necessary to come to terms about these tasks of the public prosecutors? And are there any sort of empirical studies that are trying to find out what would be more beneficial for society, what would be more sort of creating a safe society? Is there anything that's being discussed in the US?
Well, I mean, I showed you like the standards of prosecution that are the kind of the universal, but whether there's been any studies done, I mean, how do you measure whether prosecutors are using sound judgment in their decisions, in their prosecutorial decisions? Like how that seems kind of tricky to me. I mean, because I think you're right. I think if the task, like when we were looking at Japan versus Seattle, I mean, we made clear here that one was protecting the public versus the other discovering truth. But here I have, right, they're an administrator of justice, zealous advocate, officer of the court, exercising sound discretion, acting with integrity, balanced judgment. And here they have to, here it is, they should seek to protect the innocent, convict the guilty, consider the interests of victims and witnesses, and respect the constitutional and legal rights of all involved, including suspects and defendants. So what you're saying is, like, would you be able to conduct a survey to see if that in fact is they're fulfilling their tasks as a public prosecutor?
Possibly by what they are saying publicly when they are running for election. It might be, but that's just might not be very reliable.
Yeah, I think the public, well, obviously the public pushes this idea of, we don't care about sound judgment. We want you to put criminals behind bars. So you're right. And so what the public wants doesn't match up with what we're saying the duties of a prosecutor are. That's a problem. But I mean, we have judges, our state judges, a lot of them are elected, and they'll go around and tell everybody how many people they put away. I mean, how many they sentenced to long prison sentences, because they know that's what the public wants to hear.
Right.
But you're right, that doesn't match what the task of the public prosecutor is.
Mm.
Yeah. And in order to get elected, you got to convince the public.
Yeah, sure.
Yeah. Well, I'm afraid I've thrown out more questions than answers. I'm sorry.
That's perfectly.
The LP score of
deal
it.
with things.
That's the first thing we do when we do research. We need to do questions. The answers are not important. The questions are much more important than the answers.
I mean, I have to say, I really appreciate your insight and your feedback, because you see it all from such a different perspective, because your own legal systems are so different. So I appreciate your patience in letting me share, kind of our flaws, and to be able to have this opportunity to compare.
That's the most important thing. It's comparison. So it was